for the sole respondent matter. With the consent of the petitioner, my lord, my senior's mother expired, my lord. Since I'm the sole respondent, my lord, the matter may come for admission, my lord, on 10th of August.
And my lord, this matter for the last 3 occasions listed for consideration interim. So this prayer, my lord, may be considered on 10th of August. Kindly be noted.
10th of August.
My lord.
Head of Learned Council for petition.
Master bless.
My lord.
Mention item number 29, my lord. Also may not taken. I have taken consent of the my lord respondents. 29. That is summarized appeal.
All right. When?
Next week, my lord.
29
29.
is the matter before another bench.
Next week, my lord. 3 floors.
May I be the lordship, my lord, back to amendment 23, my lord. On behalf of Mr. S. Hawk, my lord. It's an engaged matter, my lord. He is not there with them, my lord. Can it be on Monday or Tuesday, my lord?
23, my lord, case diary received, my lord. Earlier also adjourned, my lord, on the day to the.
All right, Monday.
Monday.
Will it be written?
27. Obligation.
Please, your lordship. I filed an IA yesterday. There is no stay order continued. Therefore, it may be called for. Item number 33 in connection with.
Let's say I like to mention item number 48, let's see. I have already taken consent from the respondent side, let's see. 48, let's see.
Go on.
All right. The prayer of Learned Council. Consent of the respondent. The matter. 4 weeks dead.
Obliged.
Please, your lordship. Lordship, I beg to mention item 17 of today's list.
Yes.
Conducting counsel, Mr. K.K. Dotto has some pray that matter be listed after 1 week, lordship. Your pleasure, my lord.
Right, please, your lordship. Lordship, I beg to mention item number 26, my lord. That will be adjourned for the day, lordship. Can it be taken up on 28, your lordship?
All right.
May
Obliged.
please, your lordship. I beg to mention item number 30, lordship, 30. Due to some personal difficulties, we could not file the condonation of delay, lordship. So 2 weeks time may be allowed to file the same. Deeply honest. May please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 25, lordship. Pray that the matter be listed after 1 week. Obliged, lordship.
After 5th.
May I please, your lordship. I beg to mention item number 41 and 42. These matters we have filed affidavit. Records may be called.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 22, lordship. Conducting counsel A.K. Gupta has some personal difficulties.
Item?
22, lordship, 22. Lordship, 29th of July. Obliged, lordship.
4142 to
Lordship, I beg to mention
affidavit file করছে কিবা ইসিআর এর কথা কইছে না এফিডেভিট আনার কথা কইছে adjournment হইছে
Lordship, I beg to mention item 11 and 32 as my senior is out of station. So kindly pass over the matter for the day
And in item 32, we have taken concern from the respondent.
All right.
Lordship, please fix the date next week. Next week.
Yeah, please, Your Lordship. Item number 56 from the supplementary list. My lord, in this case, my lord, I was granted interim protection and today fixed CD, my lord. But my lord, CD not received, my lord. CD not received. Maybe consider, my lord, in the date of. My interim will be expired on, my lord, after 7 days. Day before yesterday, lordship has granted another 7 days time, lordship. And then maybe fixed, lordship.
All right, please take it on. They did not receive list on.
4th of August, yes.
Interim order is extended.
Maybe obliged.
Please, Your Lordship, I'd like to mention item number 45, service is not complete. It may be adjourned for 3 weeks, Your Lordship. Any date after 3 weeks.
45.
Yes, Your Lordship. Service is not complete yet. Much obliged, Your Lordship.
That is, Lordship, it is solicited method. TCR may be called for.
Call for the scan copy of TCR.
May it please your Lordship. Lordship, sir, 483 application, Lordship has already dealt with the owner of the rice, Lordship. Here is the order, Lordship. Arrow certified copy to us.
Hmm?
The owner of the rice, Lordship, has already granted to produce document, Lordship. He is the driver, Lordship. I have also placed the certified copy of the affair.
CD.
Lordship,
You ran away, I remember. You have the key and ran away.
Lordship, everything has been seized, Lordship. The vehicle and owner has been granted privilege of prayer as well. He's been detained for last 10 days, Lordship.
Yes, yes.
So,
Very little. Yes.
Lordship. Short date may be fixed, Lordship, 29th or so poor wage slave. Poor wage and Lordship. Short date then 29th, Lordship.
Other case, any that has been fixed.
It to level. He's on interim, Lordship, and this man under detention, Lordship.
We won't call for the CD on 2 different dates.
Yes, it fix.
There क्या है?
Check kori lobo, hey, date di dibo.
Yes, ma'am, I will provide that. I will check and provide.
अच्छा.
My lord, intermediate quantity, my lord, 8.1 gram heroin was recovered from the house of the petitioner. My lord, earlier anticipatory bail was considered. It was rejected by my lordship. Page 17 is the order copy, my lord. And thereafter, my lord, she has surrendered before the special judge, my lord, Morigao, on 16/6. The order I have annexment page 24. So, my lord, at this stage, city may be called for a short date, my lord. 3rd of August, if possible.
5th of August.
Obliged. I'm obliged.
আজি আহিব নেকি?
Please, your lordship. Your lordship. In this intermediate quantity, your lordship, 11.25 grams, your lordship. Charge late, your lordship. Now it is in the trial stage, your lordship. He is behind the bar for more than 120 days, your lordship. He was arrested on your lordship 25/3/2026, your lordship.
This year maybe.
Yes.
Please, lordship. The lordship, I'm paying for grant of regular bail, lordship. It is a case, lordship, the intermediate quantity, the heroin contraband, lordship. Now the present accused person's lordship, from his house, not in conscious possession recovered from this present accused person, from his house recovered from lordship, the 12.82. And lordship, the other co-accused person released on bail, lordship, I have annexed. I am in long custody and 54 days in judicial custody, lordship. The other co-accused person released on bail within the 16 days, I have annexed the phase 16, lordship.
It cannot be a ground for pending bail.
54 days. I'm behind it by 54 days.
27A is there, financing the.
Not that. Yeah, that is correct, but not 37 is bar, lordship.
37 bar is there.
And now, lordship, 54 days. Okay.
Charge is submitted.
No, lordship. Regarding that, I have no, I will have to get the instruction.
Now I'm lordship, the 54
Here
days.
is the FIR.
FIR, lordship, please. With all respect, page 10, lordship, annex 1, lordship.
So sometime I will get the instruction after taking it on.
Now, lordship, page 14, the ground of arrest, lordship, can you see the page 14? May I read with all respect, lordship? May I read page 14, lordship?
You come with the instruction first.
Yes, from the residence of the present petitioner.
At 2.
After some time.
Deeply obliged, lordship.
May I please, lordship? The second anticipatory bail application also. Rejection order is at page 30. And the FIR is at page 12 here also. 11 page start from 13.
So why should you grant you now?
Due to some medical ground here also. He has undergone a bypass, open bypass surgery, open heart surgery, and he's under continuous medication. And so for the allegation of just snatching of gold chain and snatching of 2 lakh rupees, it is completely false, Your Honor. So, lordship,
Won't go into all that.
because I have enclosed the footage of the CCTV, Your Lordship, annexures 2 series at page 16, Your Lordship. I'm ready to cooperate with the investigation, Your Lordship. It shows that the gold chain.
What medical document are you relying on? That is the only ground which we will consider.
He's in continuous medication, your lordship, and he has to
Yes, continue it in jail.
because the matter has entirely been politicized, your lordship, and if he's arrested and he tortured, your lordship. To cooperate with the investigation, he called for.
First document is discharged from hospital in the year
2021.
2021. Then coronary artery disease, good,
Next, page 29, your lordship, this is
good
the last
LV functioning.
prescription, your lordship. It is of 1/11/2025. Is in continuous observation, your lordship.
Diabetes and hypertension, my lord.
Oh, he's a cardiologist, doctor is a cardiologist.
Hmm.
Those are old documents, my lord, not yet during our filing of earlier bail petition, my lord. They have not.
Nothing is there. Heard learned counsel for the petitioner. The second application for pre-arrest bail for the petitioner. The earlier pre-arrest bail was rejected by order dated 23/06/2026 in AB 1317 of 2026 after perusal of the CD and upon finding sufficient incriminating material against them. The only new ground projected in the instant application is the medical condition of the petitioner, support whereof certain documents have been annexed. Out of which all except one document are more than 3 years old. One prescription of November 2025 has been annexed, which does not indicate any such serious conditions, because of which the petitioner cannot be taken into custody. I find no merit in this application. English stands dismissed.
Lordship, the allegation of ghost snatching is completely false, your
Correct.
May it please your lordship. May it please your lordship, we want to withdraw item number 2, daily list.
Item 5.
May please, your lordship. Lordship, pre-arrest bail application, lordship. Pre-arrest bail application, lordship. The allegation is abduction and lordship, extortion, lordship. Present petitioners are named in the FIR, lordship. FIR is on page 13, lordship. Goes by that most respectfully, may I read, lordship?
Page
13, lordship, the translated one.
Yes.
The actual fact is different than what has been, the complainant has lost the FIR lordship. Actual fact is that the local organization has gathered for raising slogan against local employment, against the company lordship. The company which has said in the FIR as Odipta Energy and Equipment Private Limited. Thereafter, some persons were detained. I have mentioned it in my para 3 lordship of page 3 lordship. Thereafter, those persons, many people gathered on that before the company for raising slogan against local employment. Thereafter, they have some person were detained. Then these two petitioner went to visit the local police station where these persons were detained. Thereafter, the FIR was lost, and other three who were earlier detained, they have been forwarded. And this person, they came back after visiting the persons who were detained, and they are also named in the FIR lodge.
Where is the forwarding report of the others?
It's not here. I have not annexed lodge.
Well, we want to
There in
see.
the statement lodge.
Otherwise, we'll call for the CD only.
Some protection may be given because there are some memorandums and other things which are being submitted by the local organization.
We
that
would
I
have,
can
but
collect with
you
interim
have
protection.
suppressed by not annexing the forwarding report, so we are not inclined to grant any interim. CD.
4/8 million.
Deeply obliged.
May I please, Your Lordship, this item may be take after some resolution. May I please, Your Lordship, I'm on interim, my lord, I've appeared. There are 24, my lord, case diary received, my lord, cases pending since, my lord, 2025, my lord. Sorry, in interim. They appeared before the.
CD received?
CD received, my lord.
Yes.
Updated. Appeared, my lord.
Huh?
On 3 occasions, which appeared, my lord, there are 7 petitioners, my lord. Lordship had granted interim on 6/11/25, my lord. Since then, the case was pending for up to the case diary, my lord.
Up to date is there.
Yes, well, the note of
Yes, what is the FIR?
page 15, my lord, our rented garage was burned down, my lord. Not updated, but one note that they appeared before the IO regarding that, my lord. Page 20 is the FIR, my lord.
Who are you, Alphas?
Yes, my lord, Alphas, my lord. They are the owners of that, my lord. Family members and the owner of the garage, my lord. Was allegedly burned down, my lord. Any legal recourse, my lord? The same process, my lord. Our house and our neighboring market was also burnt, my lord. They burned down the, my lord.
What is the material on that point?
Yes, well,
That they burned down the pit?
statement of the witnesses is there that these accused persons are involved in, my lord, burning that, my lord, involved in committing that offense. My lord.
Eyewitness?
Yes, my lord, statement of witnesses there. Your lordship may kindly.
No, is it somebody who has seen?
Yes, my lord. It cannot be that, my lord. It happened at night, my lord. We were inside our house, my lord, when it happened, my lord. There are several female members also present, my lord, in the petition. But you will see the last 3 lines of page 20, my lord. They're specifically given, my lord. Who has done what, my lord, as per the informant, my lord. Yes. Already thereafter, after, my lord, মই আহি দেখা পাওঁ যে ইতিমধ্যে জুই নুমাইছে। So after the incident, my lord, he came. We called the fire brigade and the policemen. Because when we were sleeping, the fire took place, my lord.
Granted counsel for the petitioner.
Witnesses is not there, but my lord, after the incident, my lord, they came to the place and they named that these accused persons are involved.
On what basis?
That they suspect, my lord, because we have been having a rent dispute, my lord. Rent dispute. মই আহি দেখা পাওঁ ইতিমধ্যে জুই নুমাইছে। মোক 6 মাহমান আগৰ পৰা দোকান খালী কৰিবৰ বাবে কৈছিল যদিও বেলেগত ঘৰ নোপোৱাৰ বাবে কেইদিনমান চাবলৈ ৰ'ল। দোকান কেইখন তেওঁ মোক পেট্ৰল দি জ্বলাই দিয়া হয়। মানে ডিজাৰ দি।
Order dated 6/11/25. Para 1, 2, 3. As the area is called for has been received. Next, last para. First page of order, date 6/11/25. Then next page. Again, on perusal of the CD, it is submitted that there are no eyewitnesses who have implicated the petitioners. Although the informants have stated that the petitioners have burned down the house as the same was not vacated by the informants. Pursuant to interim protection granted by this court, the petitioners had appeared before the IO. Statements had been recorded. Having regard to the above, the prayer for pre-arrest bail is allowed. Interim pre-arrest bail. Dated 6/11/25. It's hereby made absolute on the same condition.
Obliged, my lord. Highly obliged.
May I please your lordship. Lordship, though lordship have heard the matter at length on the last occasion, and learned PP has sought time for
Yes, my lord.
submission. So before that, I'll just refresh the issue, my lord. So the FIR is at page 16, my lord. So the allegation is regarding counterfeiting of notes, my lord. So nothing has been seized from my possession. It was from a vehicle which was parked under an apartment, my lord. So, and there are another aspects. That was some materials were seized from a room that was also rented by some abscond or accused persons. So no connection with that, my lord, basically. It's very clear, my lord, at page 16, this counterfeiting notes have been recovered from one Alto K10 bearing registration number so-and-so, from the dicky of which 558 numbers of suspected fake Indian currency notes of so-and-so were recovered. So that was from a dicky of an Alto car, and I'm not the registered owner of that Alto car, my lord, and neither I were in possession of that Alto car. On the last occasion, the learned PP has also considered that I was not in possession of that. I was not inside that vehicle, and neither I was inside the room, my lord. At page 17, thereafter the same police team accompanied by ACP so-and-so proceeded to room number so-and-so. So it was proceeded to room number so-and-so from the parking lot, my lord. And there they have appeared, and the room was rented in the name of some two absconder accused, my lord. One is Islam Ali and one is Sumi Bora. So they have rented out that apartment, my lord. I'm just a worker, my lord, construction worker. So I came there for construction works only in that apartment, my lord. So that is my humble submission, my lord.
Yes, Pepe.
My lord. First of all, my lord, the cars were parked in the parking area and the 3 persons, my lord, there are 2 petitions, the 3 persons were there. My lord, on search in 4 vehicle, only 1 vehicle, an Alto car, that rupees up to 2,79,000 was received. Now, the registrar, yes, he is not the registrar, my lord, and this registration is also suspected, my lord, because other vehicles name has been in the portal available, and in the these vehicles registration number when checked in the portal, my lord, I have talked with the IO, it was not found. He sought for the clearance from the to verify this. To the DTO, my lord. A report not yet received, my lord. Now to entangle this with the main culprits, we are already said out, my lord. This one Sahil and the Sumi. Now they have led to the police party to the that flat. Subsequently, flat, my lord, that materials and printing machines and other was seized. Now, my lord, there is
What
a
was
WhatsApp-
recovered?
My lord,
What was recovered from the building?
from the flat, my lord, printing machines, several printing machines and notes, cutting pages in the size appropriately size of the denomination of
So
500.
fake currency note was recovered from there also.
No,
No, my lord.
fake currency in the car and other.
Where is the
materials-
seizure list of the search of the room?
It is at
Ask-
page 19. What? No, room.
My lord, in the case there is there, my lord, seizure list is there.
My lord,
So-
it's 21, my lord. Page 21, that is the type copy. 23 is the original copy, my lord. Sorry, 25 is the original copy. One Epson printer, like this printer. One Epson printer, model number so and so, one Epson printer so and so. These all are normal printers. It's not for printing of a
In-
notes.
in
And
case-
one HP laptop, Epson so and so, 41 pieces of A4 paper. So it's an A4 paper.
Go on reading A4 paper.
My lord,
Go on reading A4 paper.
A4 paper in which 500 rupees printed in one side in all pages. Yes. Having serial number so and so, which are same in all pages. 143 piece of black paper in the size of 500 rupees so and so. 5 numbers of dimmer, iodine, tincture, IP number so and so. 1 paper trimmer, machine of black color.
Ink and all this, my lord.
6
Item 11.
Item 11, one fake note, my lord. Currency notes of 500 rupees printed in one side, wrapped in a bundle of cutted white paper of same side of so and so. My lord, I am not the possessor of that room, my lord.
No, my lord.
So I am not, neither I am a rented person therein, my lord. So there may be something, but I'm not denying that. But I was not in the position and nothing has been seized from my position.
I am disclosing from the city that something, my lord. That they have took time to go through the whole, my lord. Now there is a WhatsApp group. In that WhatsApp group, there are 8 members. And from the mobile phone of the Malad screenshot is available in the CD of the this Ziarul and Malad Annas. In that WhatsApp group, Sahil is the main person. Sahil, Ziarul, Annas, one Horu, one Sheikh, one Kamal Bora, and 2 the Suraj, driver of the Sahil, and another person were there. Now in the screenshots, Malad, they are divided team area. Who will go to which place, Malad? Team 1, team 2, team 3. They were Malad, in the car, Malad, to give sample of the counterfeit note, and subsequently, Malad, for 1 lakh rupees, they will get Malad 30,000 to 40,000. Now all directions from Sahil. There are screenshots, my lord, may peruse the screenshots, my lord. Extra duty, yes, alert out of city jabo laga hobo pare.
The petitioner is not Sahil, it is Ziarul. Does his name come?
Sahil, Ziarul, Annas is in page number 50. In the Ziarul statement also, my number.
Oh, it's zero statements, my lord.
No, Ziarul, screenshots of the mobile phones, 4-5 pages. Screenshots of the mobile phone of Annas as well as Sahil. My lord, may peruse these screenshots. All. And Sahil is taking the flat on rent. On rent. When police search in the parking area, he and the Sumi were fled away. My lord, kindly peruse these screenshots. And invest.
I'll let you hand over, we'll see later.
My lord. Fake currency, you think. In the
My lord,
backside,
I'm not denying that fake currency is a small crime. Definitely, it's a big crime. But the thing is that whether it was in my position or not, that is the question.
He is the member of that group, my lord, that WhatsApp, only 8 members. Sahil, Anas, Ziarul, or all.
And was there anything in that WhatsApp number in my name that I have communicated something with that accused person, my lord?
Instruction, my lord, given by that.
We'll see that.
My lord, may peruse.
Yes.
And the other item also similar matter, my lord, 53. Much of the
Supplementary orders.
Hmm?
Supplementary orders 57. Lordship, I'll beg for just a moment, my lord.
Five to holding.
57. Lordship, primarily, the matter concerns to my lord an NI conviction, and the IA is for suspension of sentence, my lord. Check was for 2 lakh rupees, my lord. Conviction was given for 3 lakhs, my lord. My lord, it is fixed on 27th, my lord. Next. For the accused person to appear before the concerned, my lord, jurisdictional court. My lord, I pray for the suspension of sentence, and the, my lord, appeal revision may be admitted, my lord.
It has come for the first time.
First time, my lord. First time, my lord.
But we have to issue notice on the IA suspension. Or
I can
suspension.
be disposed of today, my lord. That is a simple prayer, my lord. For
Huh?
I may be disposed of, my lord, and the I be allowed to stay on previous bail, my lord.
What is the conviction sentence?
My lord, 3 lakh and 6 months, my lord.
That is confirmed by the appellate court.
That is confirmed by the appellate court, my lord.
This is a revision.
Yes, my lord.
There is no automatic suspension. Without notice. There is a private respondent is there.
As an interim measure, my lord, on 27th, my lord.
This IA has been preferred seeking suspension of the sentence. Was by the learned trial court as affirmed by the learned appellate court. Whereby the petitioner has been convicted and sentenced to pay a fine of rupees 3 lakhs and compensation of rupees 3 lakhs.
My lord,
And imprisonment for 6 months.
6 months, my lord.
Issue notice to the respondent. The operation of the impugned sentence shall remain suspended until further order is taken on so and so. Appeal, heard so and so. This is an appeal under so and so. Admitted call for appeal, revision. Call for the TCF.
My lord, I'll take steps upon respondent number 1. Deeply obliged.
May it please your lordship. Lordship, the sole respondent had instituted a restitution petition on family court at Borpeta, and the petitioner is the wife. But the thing is that she resides in here, Kamrup Metro. At Gauhati.
Notice only at this. Heard so and so.
And the proceedings may be stay. Lordship.
Yes, to the respondent number. Further proceedings in so and so are stayed till the next date of listing. Petitioner to take steps by speed post with AD within 3 days.
Deeply obliged.
In this case, I filed a commercial suit before the learned in the court of Gauhati Lordship. That was dismissed. Thereafter, I preferred appeal before the district judge. That was also dismissed. Now, Lordship, as per judgment of this Supreme Court, no second appeal lies. So I filed application under 227. There is a judgment of division bench of the Honorable Court that no second appeal lies in commercial suits. I am challenging the judgment and order dated 9/2/2026. Where my suit was dismissed, although there is a confirmation of accounts by the defendant. Judgment it is 17 lots.
So what is your case now? It is entries and books of accounts by yourself.
Lordship, I have submitted account confirmation slip before the learned court, but learned court rejected that on the ground that certificate under section 60B has not been filed along with that document. That is in my humble submit, that is not required, Lordship. When there is a confirmation, Lordship, I have annexed that page 62. Page 62 is the account confirmation by the defendant laws.
The review was also there.
Yes, review, we filed a review also, that was also rejected. Thereafter, Lordship, we challenge the appeal, order in appeal for this Honorable Court, since there is no provision for filing second appeal.
No, what is the decree?
Decree, Lordship, suit was dismissed. Page.
Okay, suit was dismissed, then this appellate dismissed. Now, who is to pay whom now?
The defendant is to pay rupees more than 22 lakhs. If the suit was dismissed on the ground that there is no certificate from the plaintiff with respect to the account confirmation, in my humble submit, that is not required. That is required only in case of Lordship, which is downloaded from the computer logs or electronic evidences.
So what was this?
Lordship, this is page 62. Is a confirmation of accounts. Below there is a signature of defendant logs. is 62, 63, and 64, and 65. Original copy was submitted before the online trial court also.
So according to you, this is not an electronic document.
Yes, Lord.
It is simply a typed document which was signed by the
By the
Expert.
defendant.
administrator. You can learn it. Thanks, so. This is an application under Article 227 of the Constitution. Challenging the first cost title of the cell. We should note. Steps by speed post ready within 3 days. Returnable in 4 weeks. Steps by. List again on.
Much of. But the important question which arises for consideration of your lordship is that, whether the court can suo motu exercise the powers and extend the date for filing of the written statement under Order 821 without any application from the defendant and without any explanation. And secondly, my lord, whether the court can say that the mistake was committed in fixing the date for written statement after expiry of the period, that is 184 days. But because of the mistake, the right has been vested on the defendant, and thereby the written statement which was filed, that can be accepted. If the written statement was directed to file after expiry of the 184 days, and there was no application, the defendants have not appeared, and the court suo motu gave the date for filing of the written statement, the petitioner filed an application under 151 section for ex parte hearing of the suit. The court in the order has admitted that there was a mistake of the court by in fixing the date. But the court says, my lord, because there was a mistake of the court and thereby a right has been vested, accrued on the defendants to file a written statement. My lord, the order 8 rule 1 your lordship knows, my lord, the discretion is there, but it must be on the basis of an application and explanation given by the defendant for the circumstances under which the written statement could not be filed. And thereafter, the court can exercise the discretion by examining the reasons which have been given. But the court cannot, my lord, automatically and at a suo motu and in a just procedural way, my lord, without any regions, without anything, extend the date and subsequently, my lord, say that there was a mistake by the court, but because of the mistake of the court, my lord, the right is vested. These questions which arises for consideration of lordship, which needs examination by lordship in this present revision petition.
So what is the stage now? Have you come straight away after this order was passed, allowing
the petition under 151 for ex parte hearing of this suit, that is suit, my lord. The court had rejected that, and the matter is pending. It will not proceed further. Matter needs examination by lordship because, my lord, I've gone through some of the judgments. I've not found anywhere it says, my lord, that the court has the power of discretion on an application filed by the defendant, giving an explanation for the delay, but nowhere it is stated that the court can suo motu exercise the power and extend the date, and thereafter say, my lord, that there was a mistake of the court. You admitted that there was a mistake of the court.
Where is the impugned order?
Lord, Annex 12.
18,920. Huh?
11,112.
Is
112.
112, my lord.
Lordship may see third paragraph, peruse the record, case reports. It appears that the learned counsel third paragraph, Lord. It appears that the learned counsel for the plaintiff has rightly pointed out that already the stated period of 90 days for filing the return statement is left. However, on perusal of the case record, it appears the suit has been kept in abeyance for a long period of time, for which inadvertently the fact of elapsing of the 90-day period was not noticed, and again the date was fixed for filing of the written statement, although the period of filing of written statement already elapsed by order of the court. The right of the filing written statement was vested in the defendant. According to the defendant, number one, to have filed the written statement today. The lordship may skip over and thereafter I come to page 114 in the middle, my lord. Considering the circumstances, it appears that a right was vested on the defendant due to mistake of the court. But how for a mistake of the court, a right can be vested on the defendant? If there was a mistake of the court, it has to be rectified. But it cannot be said that because there was a mistake of the court, a right is vested on the defendants. And in all the cases below, the court can pass an order and have to say there was a mistake of the court and the right is vested. The discretion is there, but the discretion cannot be exercised mechanically, my lord.
Defendant cannot take advantage of the mistake. He ought to have been aware of the statutory provision and come before that time.
That's why I'm saying, my lord, that the court cannot say that, because there was a mistake by the court, so the right has been vested on the defendants. Very peculiar situation, my lord. It will have far-reaching consequences. Any court can pass any order and they have to say, my lord, there was a mistake. Now right has been vested. No application, nothing, no explanation. And when it was pointed out, the court admits that there was a mistake, but says because of the mistake of the court, right has been vested. And suo moto, my lord, the time cannot be extended. That is, my lord, nowhere it prescribes, my lord, all the judgments says, my lord, that the court has to examine the regions and all those things and thereafter pass an order. If no application is filed, how the court can extend, my lord, the time?
So the only question is whether the written statement can be taken into the record or not. That is all.
My lord.
So trial can continue.
My lord.
Trial can continue. Suit can go on.
Written statement, it can.
No. Written statement, until that question is decided, what is the difficulty in the plaintiff adducing his evidence?
I have no difficulty in producing evidence.
So should be stayed for this reason alone. If a written statement is not taken into result is that it cannot be taken into consideration, it will not be taken into consideration.
But the issue cannot be framed, my lord, without the written statement.
It can be framed even without a written statement by the court.
If your lordship so feels, my lord. But my humble submission, my lord, lordship may fix up a date after 3 weeks, 4 weeks.
Written statement is not signed and court has the power to frame issues even without a written statement.
But if the written statement is not taken into consideration, without written statement, the issues are framed.
Then that is to your advantage. Even if issues are framed without written statement. I will not say anything about the stay or anything. But Mr. Senior Counsel, as I said, this is an application under so and so. Was titled challenging the order dated so and so. Caused by the to the respondent, returnable in 4 weeks, stamped by speed post AD within 3 days. List the matter again on. So records are not necessary. I think we can discuss this. Yes.
So you'll also be in the interims, you'll also be direct something, no? Either they stay the proceedings for the 4 weeks, no?
No, that is what we said. What is the difficulty in this? Is at the stage of what?
I am here, my lord. The court will proceed with the written statement as well as with the framing the issues. unless until there is something, some obligation or order by the your lordship, my lord. The court has already passed the order that because the mistake of the court, I
No, even if issues are framed taking into consideration the written statement, if the written statement is not allowed, then there are no pleadings of the defendant anyway.
my lord, if the hearing is, my lord, the trial proceeds.
So the issues will have to be decided without the pleadings of the defendant, even if issues are
I fully
framed.
appreciate, my lord, but the written statement, once it is taken into consideration by the trial court and issues are framed, also taking into consideration the statement, my lord, there will be difficulties. Your lordship may kindly consider, my lord, that 4 weeks, the matter may be the trial, because for 1 year they are not proceeding. So for what more 4 weeks, nothing will happen.
Why is it not proceeding?
Well, that is up to the court is not proceeding. We are not doing anything.
Can that be? Well, no dates are fixed for 1 year.
My lord, we have taken, the order was passed, thereafter the court has not proceeded with. We have given, my lord, an additional affidavit also, placing all the orders subsequently, my lord. We have not taken in time. We have taken time. Let it be, my lord, after 4 weeks, when the matter is considered, this is an important question of law which lordship has to consider.
Further proceedings. This is a suit.
Suit. Number?
What is it? Title suit, money suit, what?
My lord.
What suit is it?
2024. So title suit number 84 of 2024.
State till the next date of listing. Just a second.
I'm highly obliged, bro.
May I please your lordship? My lord, this petition is filed for my lord for a limited prayer, my lord, because my lord, in this case, my lord, in terms of an agreement, my lord, settlement agreement, my lord, succession case was disposed of, my lord, and in that, my lord, order, my lord, one succession certificate, my lord, was directed to be issued after taking proper court fee, my lord. Three my lord, parties, my lord. But another, my lord, one party, my lord, is not paying the court fee, my lord. So I am in difficult, my lord. And my lord, that is why, my lord, I filed one petition under section 151, my lord, CPC, before the landed court below, my lord, for a separate, my lord, for issuing, my lord, separate succession certificate, my lord, taking proper court fee, my lord. That was, my lord, rejected. Kindly, my lord, turn to page 25, my lord, impugn order, my lord. Page 25 and page 26, my lord, third para, my lord, my lord, they, my lord, did not object to my prayer, my lord, also, my lord. It has been reflected in the order itself, my lord. That is page 26, para third. Learned counsel for the respondent submits that the respondent number 1 has instructed him to submit that as of now, she has no money to pay the court fee, and as such, she has no objection if any order is passed by this honorable by this court in the instant application filed by the petitioner. So far as the respondent number 2 is concerned, learned counsel for the respondents submit that respondent number 2 is ready and willing to contribute towards court fee. My lord, my limited payer, my lord, separate, my lord, certificate should be issued, taking, my lord, court fee, my lord, proper court fee, my lord. I am a 60 years of, my lord, a retired person, my lord, suffering from some illness, my lord, and I am in difficult, my lord.
Why do you want three succession certificates?
My lord, in favor, my lord, one certificate I need, my lord, because three parties, my lord. So they should take, my lord, two, my lord, separate, man. I want one, my lord, separately, my lord, in for my portion, my lord. Because, my lord, some amount is lying in the bank, my lord. So my share, my lord, for my share, I want, my lord, separate certificate. I will give, my lord, proper put fee, my lord, because they are not coming.
They're
And
not
one,
coming for the certificate.
yes, my lord, they are not come. That is why, my lord, I am in difficult because entire put fee I have to pay otherwise. So that cannot I bear, my lord. So that is why, my lord, page 26, my lord. My lord, they have stated that if any order, any such order is passed, they have no objection, my lord. Page 26, para third. Even, my lord, my prayer was rejected. For my share, my lord, I want one certificate, separate certificate. I will give proper put fee, my lord. After calculation, whatever is required. And the order was passed long back, my lord. 20, my lord, November 2025. Since then, my lord, they are not coming.
Succession Act.
Section 373, subsection 4, also, my lord, indicates that, my lord, it can be done for one's portion, my lord. 372 also, my lord, subsection 3.
Third learned counsel for the petitioner. This revision has been heard against an order dated 19/6/2026 passed by the learned additional district judge in Miss J case number 63 of 2026, whereby the prayer of the petitioner in an application under section 151 CPC seeking issuance of succession certificate to the petitioner separately modifying its earlier order dated 20/11/2025 passed in succession case number 61 of 2023 was rejected. It appears that by the aforesaid order dated 2011-2025, the learned court had issued a succession certificate jointly in favor of the petitioner and the respondents number 1 and 2 herein, all of whom were parties in the said succession proceeding. All of you were petitioners.
No, my lord, this petitioner was petitioner here, there, my lord, and other two respondents.
Parties. The present petitioner was also the petitioner in the aforesaid succession case, just as the present two respondents were the respondents therein. Full stop. It so transpires that the said two respondents had not come forward to obtain the succession certificates by paying their share of the court fee, because of which the petitioner also could not obtain the succession certificate, inasmuch as the petitioner would have to pay the share of the respondents, the share of court fee of the respondents payable by the respondents. Full stop. It is reflected in the impugned order that the learned counsel for the respondent number 1 had submitted that as per instructions received, the respondent number 1 had no money to pay the court fee, and as such, she had no objection if the prayer of the petitioner was allowed. Similarly, it was also recorded in the impugned order that the respondent number 2 also had no objection to the said prayer, as she did not have the capacity to contribute towards the court fee. Para. However, the learned court below was of the view that section 372 within bracket 3 or section 373 within bracket 4 of the Indian Succession Act are not attracted in the facts and circumstances case, and therefore declined the relief sought for by the petitioner. It is right that the rules of procedure are the handmaidens of justice, and in the facts and circumstances of the present case, it is evident that despite the court having issued succession certificate in favor of the petitioner, due to the incapacity of the respondents to contribute towards the court fee, the petitioner has been unable to obtain the succession certificate, which has definitely caused prejudice to the petitioner, more so as the petitioner has no capacity to remedy the situation without the assistance of the court. Full stop. It is precisely for situations of this that the inherent powers of the civil code have been preserved under section 151 of the Code of Civil Procedure. Moreover, there is no bar in any provision of the Indian Succession Act for the court to grant separate succession certificate, if the facts and circumstances so justify. Full stop. In view of the above, the impugned order is set aside. Of the learned court below is directed to issue a separate succession certificate in respect of the deaths of the deceased to the present petitioner, proportionate to her share therein. Petition stands allowed and disposed of accordingly.
Highly obliged, highly obliged.
With all respect, Lordship.
Yes.
Well, I have received the instruction, charge sheet submitted in this case. May I please, Lordship. Tisha may be called for Lordship.
All charge sheet submitted by CS number.
Case number 228/26 dated 21/7/26.
29 date maybe. 29 no. July 29. नहीं scan copy है scan copy if possible Lordship 29 Lordship.
Can go.
20 deeply obliged Lordship.
Lordship, this petition is filed against the order dated 5/2/2026, whereby the learned appellate court dismissed the delay petition and hence the title appeal is also rejected. In order is page number 69.
All right, notice. Steps by registered post to speed post AD within 3 days.
May I please, Lordship? The impugned order contained in page 15A, my lord. Order dated 17/3/2026. Lord, the situation is that, my lord, we have instituted title suit seeking declaration and consequential relief. Now, my lord, the PW4 that has already been, my lord, examined. After one, official witnesses were there. Now, in order to call the official witnesses, we have taken all steps regarding to that, my lord, attendance of the official witnesses. But since they have not shown any, my lord, indulgence to appear before the court for, my lord, deposition, now only on that for, my lord, the PWs of official witness has been closed. Now matter has been fixed for DW, my lord. Now, Lordship, kindly see order dated 17/2026 speaks what? The plaintiff and the defendant number 1 to 5 are duly repented by their learned counsel. Today, the date fixed for evidence on affidavit of the remaining PWs. Peruse the case record, it transcribed from the record date on 9/9/2025. This court allowed the plaintiff to call for the official witnesses. As per record, the plaintiff has taken sufficient step to witness, but the same has returned answered. It appears that already 5 consecutive dates, including today, have been fixed for evidence of the official witness. Today, the plaintiff side has not filed anything allowed their pair for the remaining PWs. Learned counsel for the defendant side has paid to close the plaintiff witnesses due to such negligence of the plaintiff side, heard both sides, accordingly court deemed it fit to close the plaintiff witnesses at this stage, fixed for DWs. Now, Lordship, kindly see the list of witnesses which is very pertinent in my case, because my case is set on certain documentary evidences, page 37. These are the list of witnesses, my lord. Out of which the private, my lord, parties, that is up to, my lord, 5 witnesses has already been examined. And my lord, from the downside, my lord, 18 to 22, my lord. These are the official witness to, my lord, required to call for. But Lordship, kindly see, I just want to point out only one, my lord, the provision of law, that is Order 20, Order 16, Rule 10, Sub-Rule 3, 2 and 3, my lord. This condition has not been complied with, my lord, before closing of my PWs, my lord, which is otherwise indispensable and it is a requirement of law, my lord. Order 16, Rule 10. There is a condition, my lord, say, may I read, my lord?
But just a moment, impute order is at page?
My lord, 15A, my lord, annexure 1. But it is totally, my lord, a perversity that reflects from this order at a 7.3, my lord. My lord, this is a 2018 suit, my lord. It is not my fault, it is the assertion of the court. It appears that already, as per record, the plaintiff has taken sufficient step. Where is my fault, my lord? If it would be a case that I didn't, my lord, take proper step, even also, my lord, there is a necessity to comply with Order 16, Rule 10, my lord, before closure of, my lord, PW's witnesses, my lord. Your Lordship, I just want to read Order 16, Rule 10, my lord. See.
Yes.
My lord, Order 10, Rule 16 says about procedure where witness failed to comply with summon, where a person to whom a summon has been issued either or attend to give evidence or to produce a document failed to attend or produce the document in compliance with such summon, the court A. Shall, if certificate of the servicing officer has not been verified by the affidavit or if service of the summon has effected by party or his agent, may, if certificate of the serving officer has been so verified, examine on oath the serving officer or the party of his agent, as the case may be, who has effected service or cause him to be examined by any court touching the service or non-service of the summon. This is the first condition required to comply. Now, Lordship, kindly see that in case of my lord complying of condition 1, then the trial court may enter into condition 2 and 3. The 2 and 3 says, where the court sees reason to believe that such evidence or production is material and that such person has without lawful excuse failed to attain or to produce the document in compliance with such summon or has intentionally avoided service, it may issue a proclamation requiring him to attend to give evidence or to produce the document as the time and place to be named therein. And a copy of such proclamation shall be affixed on the outer door or the conspicuous part of the house in which he already resides. 3. In lieu or at the time of issuing such proclamation or any time afterward, the court may in its discretion issue a warrant either
Yes,
or
who
without
are you
bail.
appearing for? You are appearing for whom?
So I am for 2 to
Official manner.
official respondent 2 to 5, Lordship.
Oh, minor
I am
private
the state
respondent
of
notice
Assam.
required to issue.
Heard Mr. Learned Counsel for the petitioner. So, government advocate
Lordship.
accepts notice.
He is depending
yes,
2
for
to
so and so.
minor 5.
Issue notice returnable in 4 weeks. Mr. So and so government advocate accepts for
2 to 5.
2 to 5, Lordship.
One has to
extra
go
copies
service.
be served upon him. Steps on notice to the remaining respondents. Steps by speed post with AD within 3 days.
This order may, otherwise, my lord, they will go for DW, my lord.
Impugned order dated so
73, my lord.
in
My lord, in title suit number 71 of 2018,
this state till the next date of
pending before, my lord, civil judge. Yeah.
passed by the civil ministry.
Civil judge 300 क्या, my lord. Deeply observed.
Wait, please, my lord. Lord, I am preferring this present petition challenging the impugn order passed by the learned additional district judge Dibrugarh, my lord. My lord, the impugn order is in page number 71. Lordship, permission, may I please read the order?
Yes.
Heard on the petition filed by the petitioner under section 24 of the Hindu Marriage Act 1955, praying for maintenance, pendant light and litigation expenses during the pendency of the proceedings. I have gone through the petition and the written objection filed by the respondent. In the petition, the petitioner has claimed that the respondent is employed in a private company and earns a monthly salary of rupees 70,000. On that basis, the petitioner has paid for monthly maintenance during the pendency of the case at the rate of rupees 30,000 per month along with litigation expenses. On the other side, the respondent in his written objection has submitted that he earns only rupees 18,496 per month. The respondent, however, has admitted that he has been paying an amount of rupees 5,000 to 10,000 per month to the petitioner. In support of his submission, the respondent has placed on record bank transaction documents to establish that he has been depositing a sum of rupees 10,000 per month to the account of the petitioner. I have carefully perused the affidavit submitted by both the parties. As this is a matter relating to monthly interim maintenance under Section 24 of the Hindu Marriage Act 1955, I refrain from entering into the merits of the case at this stage, particularly with regard to the income of the respondent. After considering the status of both the parties and all other attending circumstances, I direct the respondent to continue to pay rupees 10,000 per month as monthly maintenance to the petitioner till the disposal of the case. The petitioner is also entitled to litigation expense of rupees 25,000 as one-time measure, my lord. My lord, I am aggrieved by this impugn order dated 3/6/2026. My lord, if I take my lord to page number 63 of the affidavit of assets and liabilities filed by me, I have clearly stated there, page number 63, my lord. I've clearly stated in page number 63, my lord, my monthly salary is 18,496, my lord. Uh, last three point. From the last, my lord.
But you were paying 10,000.
That at that point of time, we were residing together, my lord. Now I am residing separately in Gauhati, my lord, and I have other expenses also, my lord. Like I have to pay the rented rooms. I stay in a rented room. Plus, I also have a dependent brother, my lord, who is dependent upon me. He's suffering from liver cirrhosis, my lord. My lord, I don't have any problem in paying the maintenance. I am ready and willing to pay, but 10,000 is more than 50% of my income, my lord. If my income is 18,496, if I pay 10,000 as a maintenance to her, how am I supposed to look after other financial responsibilities that I have, my lord? In addition, my lord, she has also landed property in her name, from which,
You were working in the private sector.
yes, my lord.
As what? You have not annexed any salary slip in support of your contention.
My lord, if I take my lord to page number 67.
Where is her statement? All right, notice stage heard counsel for the petitioner. With an application under so and so, challenging the order dated
Pay 5,000.
so and so. The respondent appears. Notice returnable 4 weeks. Steps by speed post to AD within 3 days. Again on so and so. Date.
May I plead your lordship kindly adjourn the matter for next week.
Next week.
Next week.
Huh?
Next week.
List again.
The petitioners herein initially filed a proceeding for grant of letters of administration, Your Lordship, in the year 2021. During the pendency, the respondent filed a suit for partition in the year 2024. We have appeared in the partition suit, filed our WS, and thereafter filed a petition under section 10, read with section 151 CPC, praying for stay of the partition proceeding, as the material, as the probate suit or the letters of administration suit will have direct impact on the proceeding of the partition suit. That was rejected, Your Lordship. Section 10 petition was rejected, holding that the proceeding under the Indian Succession Act and the partition suit are different, and that those are not similar, Your Lordship. Impugned order starts at page 40. Page 43 is the reasoning, Your Lordship, in para 9. Page 43. In the present case, as per the pleadings of both the sides, the defendant relies upon pendency of Miss LA case number 23 of 21 relating to an alleged will dated so and so. On the other hand, the plaintiff has specifically stated that the relief in the said Miss case and the present suit are totally different from the materials on record. Also, it appears that the present suit is a partition suit wherein determination of shares and division of his suit property is involved. The proceeding referred to by the defendant in Miss LA case arise out of alleged will. Thus, the nature of the proceedings and the issues involved are not shown to be identical. The defendant has not been able to establish the matter that the matter in issue in both the proceeding is directly and substantially the same, or that the whole subject matter is identical, Your Lordship. For this reason, my petition under section 10 has been rejected, Your Lordship. Both the proceedings, one before the Honorable District Judge Bongaigaon, another before the learned Civil Judge Junior Division, are proceeding simultaneously, Your Lordship.
So you are yet to file written statement.
I have filed my written statement. I have annexed it here as well. After filing the written statement, I have filed the petition under section 10, Your Lordship.
So what is the stage of the suit now? Issues?
is for, it is in the stage of SBPH, your lordship. The next date is on 24/7, your lordship. Today is 24/7, it's fixed today.
Has not progressed to field evidence.
But my,
All right, hard learned counsel. An application under challenging an order dated students. Unable in. Take steps by speed post with AD. Records will be necessary, scan copies will be necessary.
copies,
We may have to examine whether the issues are same or not.
lordship, that
Call for the scan copies of the list again on.
the returnable date, if the proceedings,
Consider on that date.
lordship, that observation may be on the returnable date, the prayer first.
Therefore, interim relief shall be on the returnable date.
Wait, your lordship. My lord, see, against the impugn order, lordship will find page 54, my lord.
Before we proceed, we have not been furnished with a copy yet. I appear on behalf of the Standing Council of Forest. Our
Of?
name, Standing Council of Forest. We have not yet been furnished with a copy.
Forest Department.
You have submitted that government. We will submit, my lord. I will supply, my lord.
This is against what?
My lord, against the impugn order, lordship will find page 54, my lord. My lord, the respondent filed a petition under order 14 rule 2 of sub rule 2, my lord, for this is without jurisdiction of the court, and so to frame a preliminary issue, and accordingly, learned trial court, my lord, frame this issue, my lord, which is, my lord, not accordance with law, my lord, because there is a mixed question of facts and law involved in this case, my lord. And after 2 years.
What is the impugn order?
Page 54, lordship.
So what is wrong with this order?
My lord, this is wrong because, my lord, this lordship may kindly see the plaint and the pleading there on and the issue already framed, my lord. And this is, my lord, regarding right title and interest of a land, my lord. This is partial land of the petitioner, my lord. And in this regard, lordship, a report also called from the settlement officer, my lord. And settlement officer submitted a report, my lord, on this point, my lord, while my lord passing in order in my lord injunction petition. This honorable learned trial court also recorded that it is required to, my lord, go for the trial. Lordship will find that order, my lord. It will be clear from page 63, my lord. Page 63 is a order, my lord, which was passed on order 39, my lord, rule 1-2 CPC, my lord.
So the preliminary question is whether the court has jurisdiction to try the instant suit.
Yes, my lord.
So on this issue, you can take up your claim that it is a patta land, so it is court has jurisdiction.
My lord, this will, my lord, delay the proceeding because lordship may kindly see the provision, my lord. This is, my lord, order 14, rule 2, sub rule 2, my lord.
Yes.
Lordship, may I read, my lord?
It's reflected in the order itself.
Yes, that also reflected, my lord. And as per my lord, my lord, decision of our court and the Supreme Court, my lord, when and how a court can, my lord, pass an order for issue of preliminary issue, my lord. Only when there is, my lord, jurisdiction of law, my lord. But in this case, my lord, not only the jurisdiction, my lord, but also my right, my lord. And this is the mixed question of facts and law. When there is a, my lord, from the pleading and the issue already framed, my lord, and the order passed by the trial court, my lord, it seems, my lord, this is a dispute, my lord. My lord, serious question of, my lord, facts and law is involved here, my lord. And in that point of view, my lord, the court cannot, my lord, pass this order, my lord, in this stage, my lord. Lordship, in our High Court also held, my lord.
So what has happened after framing of this is an old order.
This is
April.
The other issue remain, my lord, Captain Against, and this will go first, my lord, preliminary issue, my lord.
So what has happened after that? Next date was in April.
Hearing pending for hearing, my lord. Regarding, my lord, issue already framed, and then it will start further proceeding. This is, my lord, from the impine order itself, my lord. 623 for 26 for hearing on preliminary issue.
That is what we are asking.
Yes, my lord.
After
Thereafter,
that,
my
many
lord.
dates must have gone.
No,
Only for hearing.
This order remain no further hearing, my lord. On our side, we have taken adjournment last side. There are 20 lordship in our High Court order, my lord. Supreme Court. And para 13 of the Honorable Supreme Court, my lord.
But we have to decide this issue, so.
But we have not been served a copy, our names also were not reflected. So I just ask any short date so that we can get the copy and we can submit our observations and be able to assist the court on this matter.
Lordship may issue notice, my lord. Meantime, my lord, the proceeding may be, my lord, state, and we will supply copy, my lord. So this is a question of law, my lord. And
as we are unable to submit our observations, if stay is granted, then it'll be difficult on us.
If you want stay, you should have ensured service first.
First.
Next Friday?
What?
Next Friday?
My lord, the names may be reflected, our names are not reflected.
Can it be on Wednesday, my lord?
All right, Wednesday. This matter again on Wednesday, showing the name of standing counsel for Forest Department in the respondent column. In the meantime, petitioner shall serve copy on learned standing counsel who is present today during the course of the day. Again, nonsense.
All right.
May it please your lordship. Lordship, in this case, I am appearing as legal aid counsel, lordship.
Lordship, what has happened, the petitioner has filed a petition under Order 23, Rule 1(3) of CPC for withdrawal of the suit, Lordship. And that was subsequently allowed, Lordship. Kindly peruse page 33, Lordship. Which was subsequently allowed. Second paragraph, Lordship. Based on foregoing discussions, thus I am of the considered opinion that the defects in non-impleading necessary parties to the suit and errors in stating cause of action and other legal facts pleaded by the plaintiff can be considered as formal defects, and under circumstances, I am of the considered opinion that plaintiff has been able to show sufficient grounds to grant him relief as sought by him. Accordingly, petition so-and-so is allowed, thereby allowing withdrawal of the suit by the plaintiff with a liberty to file a fresh suit. However, considering the fact that though not at belated stage of the suit, the plaintiff since filing of the suit after a considerable period of delay has filed the present petition, which definitely has caused unnecessary harassment to the defendants. Has petition is allowed only by imposing a cost of rupees 10,000 payable to defendants, Lordship. Only that part, Lordship. Cost part, Lordship.
Only written statement was filed.
Lordship. Trial is yet to commence, Lordship, which is clearly reflected in page 32, Lordship.
What?
It appears that plaintiff has filed the petition at the stage of the suit where trial is yet to be commenced, as issues in the case is not yet framed, and none of the parties have adduced evidence, Lordship. That part is there, Lordship.
Now, if we issue notice on this one, he'll face more harassment.
Lordship.
Well, legal aid counsel.
Lordship, actually, they have filed application before the legal aid, Gauhati High Court legal aid authority, Lordship. Thereafter, they have engaged me file this case, Lordship. Because they poor people, Lordship, getting legal help.
He has had to file his written statement and spend some money. Now you withdraw and file another, then he will again have to file written statement.
Lordship.
Engaging lawyer. So some harassment has been caused. So you should pay something, if not 10,000.
Lordship.
Get your instruction then.
Lordship, whether, Lordship, with regard to Lordship,
Instead of 10,000, we cannot say learned court is entirely wrong because even though it has not progressed to evidence,
Lordship,
defendant has filed written statement by engaging lawyer, some expenses has been incurred. So why should he not be entitled to some compensation? If you want to withdraw, if it is case is to be withdrawn for your fault. So what we are saying is instead of 10,000, you should be agreeable to pay something.
that I will take instructions, Lordship,
Yes.
at 2 p.m., Lordship.
All right.
Oblige, Your Lordship.
May it please your lordship. Lordship, what has happened is my mother filed a 166 claim petition on the death of my elder brother. And during the pendency of proceedings, she passed away. So subsequently, I filed 2 petitions for striking out her name and impleading myself as claimant. So the impugned order is at page number 24, my lord. By this order, the tribunal has rejected my petitions and also dismissed the original MV case. So, my lords, we're selling that. At this stage, my lords, notice may be issued.
All right, notice. Order, okay, steps within 3 days.
Oblige.
May I please, Your Lordship? In this case, the plaintiff got a decree in a suit for specific performance, and he filed an execution case. Your Honor will find the operative part of the judgment at page 33. The defendant number 1 is bound to execute a registered sale in respect of Schedule LN with the building thereof in favor of the respondent plaintiff. The defendant 1 shall do the needful for execution within a period of 3 months from today, failing which the plaintiff is entitled to get the execution of the registered sale deed through the intervention of the court. The plaintiff is also entitled to cast possession of the scheduled land by the efficacy defendant 1 and so on. Now, my lord, there is a notification subsequently which was issued by the government of Assam, my lord, with regard to inter-religion transfer. That is at page 45. Now, basing on this notification, my lord, where, my lord, NOC is to be obtained for inter-religion, my lord, sale, the learned executing court at page 48 has passed an order keeping the execution proceeding in pending, saying that unless until you obtain such, the parties obtain such permission, NOC.
All right, notice.
Fine. Diplomat.
May it please, your lordship. My lord, we suffered an ex parte decree, which your lordship finds at page 24. We were the defendants in the suit, my lord. The suit proceeded ex parte, and an ex parte decree was passed, which your lordship finds at page 24. Now, this was, the suit itself was treated to be one under section 6 of the Specific Relief Act, and recovery of possession was ordered, my lord. Lord, execution proceedings were initiated, and thereafter, upon visit of the civil Nazir, we came to know about the decree. We immediately filed 2 applications, my lord. One for condonation of delay, and the other for vacating the ex parte order. Now, though on 2/7/26, the condonation was allowed, my lord. Condonation was allowed, and the main application for Order 9 Rule 13 was fixed on 9/7/2026, my lord. Now, 9/7/2026 happened to be that strike of the court staff, my lord, and therefore that hearing got postponed to now to 26/8/2026. Now, meanwhile, there was already a direction for police help to execute the decree. So therefore, we filed an application that since the condonation has already been allowed and the Order 9 Rule 13 is pending adjudication, the execution should not proceed, at least till decision in the Order 9 Rule 13. That application has been dismissed. My prayer at this moment is only that the Order 9 Rule 13 application, if that's taken up, it's already fixed on the 26th of August. Until then, if the recovery is ordered, the writ is executed. In fact, Your Lordship finds there is already a standing order for police help, which is at page 60. This order is already there. Another aspect, my lord, the condonation, the application, if Your Lordship sees the applications for condonation and for vacating the ex parte decree, my lord, it's more or less the same grounds, my lord. In fact, identical. Now, in the context of Section 5, the court has already held that there is sufficient cause. So, chances are that the same view will remain insofar as Order 9 Rule 13 is concerned, my lord, since the grounds are identical. At this juncture, my lord, if the execution is done, my lord, irreparable loss is likely to be caused. Of course, the court has held that filing of Order 9 Rule 13, impugned order is at page 79. You know? That is where the court has held that filing of Order 9 Rule 13 by itself will not be sufficient to stay it. However, the judgments of various high courts have consistently held in such a situation, there could be a possible race among the execution proceedings and the Order 9 Rule 13 proceedings. Therefore, the execution should ideally be stayed. The Punjab and Haryana High Court and Madhya Pradesh High Court have taken that view. But in fact, there is
The impugned order rejecting your application. That is
page 79. After Another aspect, if I may just quickly point out, page 37. In fact, my lord, there's a lot of uncertainty in the decree because the circle officer has reported that I could not identify the land by the DAG number. Page 37 for a moment, if I may just point out.
That is why, is there any need to stay any execution proceeding in our country?
Yes, my lord, because now the court has said, regardless of the discrepancy in the DAG number, it should be executed by the decree. Police should also go. And next date is again fixed for report. Page 37, your lordship finds, in fact, the Nazir had initially reported that I could not, that DAG appears to be Sarkari, which is shown in the decree. Now, that if it is government land, you know, then the court says at page 78, para 7, page 38, para 7, that though the boundaries are, the DAG number is incorrect, it should be executed as per the boundary. Now, with these orders looming large over me, my lord, and I ultimately Order 9 Rule 13 is fixed in the month of August, 26th of August today. So at least until that time,
Third learned counsel for the petitioner. Challenging the order dated. By speed post AD with the result of the readings and the impugned order. Limit paid to pay further stay the execution proceedings till disposal of the application.
Miss J 25.
You're setting aside application.
Yes, yes.
Yes,
27.
application number.
Miss J case number 27 of 2026.
Order 9 Rule 13 CPC. List again. Since
Deeply obliged.
petitioner may respondent may come up for verification of vacation of the interim order passed today.
Right. Obliged.
Please, Your Lordship. Lordship, the engaged counsel is on legs, Your Lordship. I pray after some time or at 2, Your Lordship.
After some time.
May I plead the Lordship? In this case, my lord, this is a concurrent finding by the learned trial court and the first appellate court, my lord. What happened, my lord? The Suitland, my lord, one Sukram Nunia was the original owner and pattadar of land measuring 4 kathas, my lord. I'm giving a lordship the background of the case, my lord. Sukram Nunia has, my lord, 2 sons and 1 daughter, my lord, Hiralal Panna and Basanti, my lord. The allegation in the plain that the predecessor of the present defendants and the appellants, my lord, Pannalal Nunia sold out 2 kathas of land to the respondent herein, my lord, by executing a register sale deed. The register sale deed was executed and as per the affirmance made in the plain, my lord, possession was handed over. However, your lordship will find the plain, my lord, at page 15. He has filed this suit for declaration of right, title and interest as well as, my lord, recovery of possession, my lord. We appeared, my lord, file our written statement denying that, my lord, we did not executed any sale deed, my lord. But as per plaintiff, my lord, he has been dispossessed on 7/12/1982, my lord. Sorry, my lord, 17/5/1998, my lord. The register sale deed was executed on 7/12/82, my lord. He was dispossessed 17/5/1998. That your lordship will find, my lord, page 16. May I read, my lord?
Yes.
Yes, paragraph 5 in page 16, my lord. That the plaintiff has been continuously possessing the said land and Exali house without any dispute and interruption till and until before 17/5/1998, when the defendant forcibly dispossessed the plaintiff, ousting him out of the land, and from 17/5/1998. My lord, this is the date of the, my lord, dispossession. Thereafter, my lord, the plaintiff instituted the suit on in the year 2012, my lord. That is the, my lord, beyond the period of limitation, my lord. He ought to have filed any suit, my lord, for his disposition, my lord, within the period of, my lord, 12 years, as per 64 of this Limitation Act, my lord.
So what was the decision of the court in this regard?
Decision, my lord, my lord, the learned trial court, my lord, frame as many as, my lord, 8 issues, my lord, that your lordship will find page 38, my lord. The issue of limitation was never, my lord, framed, my lord. So that issue was, my lord, not answered, my lord.
Never framed means never taken up in written statement.
Yes, my lord, we have taken, my lord. Your lordship will see, my lord, page 23, my lord, in our WS, my lord. Kindly have a look, my lord.
Page?
Page 23, my lord, paragraph 9. That this suit is barred by law of limitation. This is, my lord, general plea, my lord. Page 26, my lord. This is my lord, my defense, my lord. Page 26, my lord. Just 3 lines before paragraph 17, my lord. Even assuming but not admitting that this defendant disposes the plaintiff on 17,598 from the suit land and took forcible possession of the same, this suit becomes time barred and liable to be dismissed. This is
Yes, where are the issues?
Issues, my lord, your lordship will find 38, my lord, in the trial court judgment. These are the issues, my lord, whether there is cause of action, whether it is suit for non-joinder and non-joinder of necessary parties, whether suit is bad for section 34, whether plaintiff has right title interest, my lord, these 5, my lord, whether the defendant disposes the plaintiff from the suit land on 17/5/1998 by trespassing into the suit land, whether the defendant is a trespasser, and 7 and 8 to that. So this suit was secret, my lord, and recovery of possession was granted. Against that, my lord, title appeal was filed. Again, we have taken the plea of, my lord, limitation, my lord. While deciding the plea of limitation, my lord, your lordship will find page 103 of the appellate court judgment, my lord. His finding is that, my lord, we did not have claim any adverse person, my lord. We did not file any counter claim, my lord. So, my lord, adverse person cannot be, my lord, raised, my lord. Page 107, my lord. 10, kindly see, my lord, 103, my lord. This is a
Is
finding.
it necessary in all cases to file counterclaim if you set up adverse position as
No,
a
man, no, man. This I have stated that this is my land, my lord. I never sold, my lord. If I claim the adverse person, my lord, their suit is not maintainable, my lord. Why should I file a counterclaim against my land, own land, my lord? This is the finding of 103, my lord. Page 103, my lord. Though the defendants asserted continuous person over the suit land, no clear plea of adverse evidence was brought on record regarding the exact commencement or hostile adverse person against the plaintiff after the alleged sale deed of the year 1982. This
that was not your pleading.
Not my pleading. This is completely perverse finding, my lord. If your lordship finds my substantial question of law at page 10, my lord. A, my lord. 1. Whether the learned courts below committed grave error in law and procedural perversity in completely expunging the evidence of the decree. Number 2. Whether the plaintiff suit for declaring the title and recovery of khas person is expressly barred by the limitation under Article 64 and 65 of Limitation Act, the specific date of alleged disposition being 17/5/1998 and the suit being instituted only in the year 2012 after a lapse of about 14 years, my lord. This substantial question law may be suffice, my lord. The present case, my lord.
Number 1. Which one?
This is number 2, my lord.
Learned counsel for the concurrent findings of fact. by the MP on judgments stated so and so দুটা থাকিব the trial court. The bill is admitted on the following substantial question, page 11, 2 para. Call for the records. The respondent. By speed post AD. It is.
I, my lord, for stay, my lord.
IA 2373. IA has been referred. The first title. Regard to the substantial question of law formulated in the connect order, the execution of the decree till the next returnable date.
I'm deeply obliged, my lord.
Please, Your Honor. Your Lordship peruse order take 5/4/2019, my lord. The service is complete, my lord.
Have been listed for hearing.
In usual course, my lord.
Sir is ready for hearing. List. Hearing. Sir. Sir, waiting 4 weeks. Learn.
Respondent number 1.
One is who?
A Burman, respondent number on behalf of K Bhattacharya.
How many respondents?
My lord, there are altogether, my lord, 14 respondents. They are appearing for 1 and 2.
One.
One.
Only one.
Again, did after 4 weeks.
My pleasure. The next lower court report was called for. Does
it come?
Report.
This is item 31. No, I don't think it has come.
31.
Note. As per office note 22/7/26. This year has not been received. Issue reminder list again on.
Your Lordship, a matter has been listed for order. In the last occasion, stay order not continued. That's why I filed an IA. I order before Your Lordship today. Because in IA, at page, kindly turn it to page 3.
What is that order of date of the stay order?
Stay order
19/9.
99. Kindly page in IA at page 22. Internal page 23 of IA. The stay order granted up to 16/10/2025. On 16/10/2025, the matter listed before this honorable court, and on that day, it's correction, the name of the respondent number, surname has been wrongly typed. That's why paid for correction. And honorable court was pleased to allow, and accordingly amended and corrected civil division petition has been filed. But last two occasions, matter listed but could not reach.
Have you filed the corrected cost title after that?
Yes. That 2 times listed, but not least by page. My lord, kindly turn into page. Page 28. 28 and 29 of IA. And at page 28, Alexa F series, order date 13/5/2028, left out. And next, page 29 also, 29, order dated 25/2026. Matter left out, even though listed. That's why the for stay order could not be continued, hence it is the petitioner has filed this Eastern IA. Matter may be revision petition may be fixed for admission hearing for disposal, but the matter has been fixed 31st 7/2026 for argument in the trial court. Matter has been fixed for argument in the trial court on 31st July 2026.
You are for?
I am for the respondent number 2. But here, my lord.
Who is one?
Huh?
One.
One is not represented, man. I am for the respondent number 2. I just point out, my lord, the order dated 19/9/2025, when the stay order was granted. Page 23, my lord. Page 23. My lord, just from the below, my lord may see 1, 2, 3, 4, fourth line from the below. Page 23.
Yes.
This honorable court has observed, it appears that stay of the proceeding may be granted at least till the next date of listing. Further proceeding of TS number so and so is hereby stayed till 16/10/2025. Notice to be issued to respondent number 1, routed through dusty service, because on that very day I was appeared, my lord. I was on caveat, returnable on 16/10/2025, list on 16/10/2005. This matter may be taken up for final disposal on the next date fixed. So under this context, my lord, till 16/10/2025, my lord, stay was granted. Because, my lord, what had happened in this case, my lord, the main issue is, my lord, the plaintiff, I am the plaintiff, my lord, and they are the defendant, my lord. When the matter was fixed for cross-examination of PWs, they sought for 6 adjournment. Thereafter, my lord, court was granted, fixed the matter for DW. When the matter was fixed for DW, there also they have taken 3 times date for adducing their DWs. Subsequently, my lord, they have approached this court. As because we are in caveat, my lord, we have appeared on the very first date, that is on 19/9/2025, and on that day, my lord, stay was granted up to 16/10/2025 with an observation that the matter will be taken up for final disposal on the next date fixed. Well, on that day, my lord, stay was not continued, my lord. Subsequently, my lord, before this honorable court, the matter was listed on 2 occasions, my lord. That is on 13/5/2026 and my lord on 20/05/2026. My lord, he has referred, my lord, the matter was left out. But my lord, it was his duty to make a prayer for continuing his, my lord, interim stay, my lord. That was not extended. Therefore, my lord, the learned trial court on time and again, my lord, asks for, my lord, submission of the order of the Honorable High Court, my lord. Because at that order says, my lord, it was stayed for 1610. My lord, the
What is
petitioner
the
has
date of the argument fixed now?
31/7.
31.
31/7. So we fix it for admission on the next day to dispose of it.
I'm ready. But till next day.
Fix it on Tuesday.
My lord may have it on 30, my lord. My lord may have it on 30/07, my lord.
The argument date is 31st.
31st, my lord.
I'm ready to.
All
argue
my
the-
lord can take up this matter today itself.
Actually, what happened, my lord, the honorable judge with an intention to early disposal of this petition, that's why till next day fix. And accordingly on that day ought to have disposal. But some certain technical difficulty. it could not be.
30.
My lord?
30th.
Yes.
We'll dispose of finally. The argument is on 31st.
yes.
So what is the necessity of
Yes, sir.
extending any stay?
Yes.
Third learned counsel for the petitioner. And learned counsel for the respondent number 2. None appears for respondent number 1, although service is complete. This is the matter for admission hearing. In the admission column on 30, an attempt shall be made to dispose of the matter on that day. To finally hear the matter on that day. As the next date of argument before the learned trial court is fixed on 31st.
Must. Must.
Lord, we are appearing on behalf of all the respondent here. But one fact I'd like to inform your lordships. When the matter was moved on 7/5/2026, Lord, our caveat was there, but nonetheless, my lord, we are never informed, no copy was served, and they have taken an ex parte order.
This is the second appeal we have to hear anyway.
That's all right, but then, my lord, your lordship kindly say, these practices not good. After all, because our client will think otherwise. They have engaged us, we filed a caveat, and we are not heard. It is on the fault of the, my lord, the appellant side only.
That is the job of the registry, not the appellant, your lordship.
It's all right, but then.
We never received a copy.
Well,
That is a
they-
false statement.
The
We
copy.
never received a copy of the.
Why do you say all these things? Don't tell double lies before the court.
That shows some proof, sir. Then you are making allegation that we are.
The allegation we are making rightly. And if they suppressed all these things, then boldly again he is making all these
It
statements.
is
once
the
again.
duty of registry to give us the copy, and if it.
My lord, in that I don't want that any verification should go on that because the official staff will be in problem. But then whatever has happened, they should not boldly again say all these things once again. Want proof, that proof can be produced, but I am not on that. Anyway, my lord, your lordship may do one thing.
Has the TCR come?
Yes, the LCR has come, your lordship may fix a date of hearing. In both the court, they have lost.
There is an interim order, your lordship, that may be extended.
Learned appellant and learned appearing for the respondents number.
All the respondents.
The respondents who were on caveat. It is already admitted. List the matter for hearing on. Even it.
The interim order, your lordship, the interim order may be extended.
Interim order passed earlier to continue the next date of listing. Anyway, good to know that the practice hasn't changed since my days in the bar.
Very unfortunate these things, my lord. We, the advocates are also responsible for that. Obliged.
May please, your lordship. Lordship, service is complete. The respondents have appeared. But we may come up for admission only.
Lordship, we need some time for filing a objection.
All right, in the meantime, you file. Heard learned counsel for the petitioner. Respondent has entered appearance. Is the matter for admission on so and so. In the meantime, objection may be filed by the respondent.
Well, the interim order may be extended.
Interim order passed earlier to continue. Date of listing.
Obliged.
Yeah, very good, Lordship. As per office note dated, unsub noticed has been returned, Lordship. Insufficient address. Kindly allow us to take fresh steps, Lordship.
Don't
And interim may be
learned
continued.
counsel for the petitioner prays for time to take fresh steps. Furnishing proper address.
Interim may be continued.
List again on so and so. In order passed earlier. Next date of listing.
Right, your lords. Lord, in this, this is sole respondent, my lord. We have taken a step, my lord. And as per office note dated 21/7/2026, my lord, the notice is returned, but without comment in the envelope, my lord. My lord, this address we have given from the lower court, my lord, because in the lower court, he is the plaintiff, my lord. So, my lord, I pray, my lord, if lordship allow, we will take a step through his advocate, my lord, because this case is fixed on 13th of this month.
If he accepts, if he is still holding the brief.
Pardon, man.
He may no longer be their advocate.
No, my lord, we have known the advocate, my lord, because trial is going on, my lord.
This is a pending trial.
Pending trial, my lord. We have submitted a petition for
As
rejection of
per
the
office
plain.
note dated 21/7/26, unserved notice has been returned without any comment on the envelope. Learned counsel for the petitioner prays for effecting service on the learned counsel for the respondent as the case is pending before the learned trial court where where the respondent is represented by learned counsel. Prayer is allowed. List again on petitioner to submit affidavit of service.
Obliged.
Preparing for respondent number 1 to 4, Lordship.
Lordship, service is already done.
So to be listed for admission now, or is it admitted?
Date.
Hmm?
The next date.
Lordship,
Only fixed date for admission.
Lordship, there is a subsequent development in the case. Your Lordship, petition number 3, Narayan Devnath has already expired on 18 July 2026. Your Lordship, we would like to submit a formal substitution application within short period, Your Lordship.
Learned counsel for the petitioner. Respondents number 1 to 4 are also represented by learned counsel. Submitted that who has expired?
Lordship,
Who expired?
petition number 3, Narayan Devnath.
Petitioner number, it is submitted that petitioner number 3 has expired and time is sought to file application for substitution. Prayer is allowed. Again. So and so in the meantime, said application may be filed.
Lordship, we are protected by the Honorable Court's order from the eviction of the disputed. So interim order may be continued, Your Lordship.
If any, stands continued till the next date of listing.
Thank you, Honorable.
Jolly, matter.
Wait, please, Your Lordship. The office note 22/7/2020. Oh, to me, sir.
I'm appealing for acknowledgement, my lord. I have filed our call number today, my lord.
Third, learned counsel for the petitioner. Learned counsel has entered appearance for respondent number. Sole
respondent.
Sole respondent submits that Wagalatnama has been filed. Okay.
Yeah.
It will list the matter showing the name of learned counsel for the respondent in the cause list.
After 3 weeks,
There is an interim, Your Lordship.
First.
plus.
Very grateful, Your Lordship.
May I please, Your Lordship? This matter, the service is complete.
That's why I'm appearing for all the respondent. So I
Heard learned counsel for the petitioner. Appearance is entered by Mr.
be there, Lordship.
for all the respondents. But you're going to file something.
I file an affidavit of origin. Written there.
There is an interim order, Lordship.
The matter again on so and so. May file affidavit in the meantime. Interim order passed earlier to continue till the next date.
Deeply obliged.
Wait, please, Your Lordship. Lordships, in this matter, we have taken steps upon the sole respondent in terms of the order dated 10/6/2026. Lordships may have office note dated 22/7/26.
Trustee, you have not submitted affidavit.
Yes, submitted. It's on record.
Now, no, today.
Yes.
What, you have affected or not?
That's the.
You could submit or not? Refuse to accept.
Notice issued by speed post has returned unserved. Notice issued by usual court process has not been received till date.
So Dusty also.
Dusty, they have refused to receive the same. We have tried to hand it over to them.
That is no good.
For the.
I don't know.
Bennett.
Affidavit of Dusty has been submitted stating that respondent refused to accept service. Process server's report has not been received till date. This family court report. Report from family court has been received stating that settlement between the parties is not possible. What to do? We have to await service. Wait.
There is an interim order also. Same
interim order passed earlier to continue. There is interim order, then why is he refusing service?
Refusing it. They are deliberately trying to avoid the court proceeding. They know it very well that this matter is going on.
Material case. Next material.
Grateful.
Lord, this matter, there's a talk of compromise going on. Date is fixed on 31/7. Your Lordship will find we did not take steps because of that reason, because we are going to compromise. So let it
As
come.
Dr. Learned Senior Counsel submits, the talk of compromise is underway, which is why steps have not been taken. Hence, list the matter again after
After 2 weeks.
2 weeks on so and so date.
Much obliged.
Yes. Who is there?
Madam, I'm appearing for respondents 6 to 9.
And appears for the petitioner as per office note. Steps have not been received by the section for usual court process. List again after 4 weeks.
My lord, I'm sorry to say, your lordship, I could not take a step, my lord. By tomorrow, I will take a step, your lordship.
Counsel for the petitioner submits that will take steps within 2 days. Hence, list the matter again on.
Obliged, sir.
May I please, my lord? My lord, there are two IAs pending, my lord. I request my lord to take up the second IA. IA number is 1455. my lord.
They will take up at 2 then.
Yes, yes.
Let please, your Lordship. Also, other side has appeared in this matter. Matter may be fixed for admission.
It counsel has entered appearance for respondent number.
Full respondent.
For the sole respondent. Here. Here is called for has not been received. Issue reminder. Again.
Lordship, I have to make a submission, not with regard to this case, another case, item number 30. In that item, they have not informed me, and I am for the respondent in that case. I am for the matter has already been abated. Now they are adjourning the matter since long.
The next date.
Please, your Lordship. Lordship, in this case, what has happened? The respondent has instituted a title suit, Lordship, before the Court of the Learned Civil Judge Senior Division Tezpur, seeking eviction of the defendants, that is, performer respondents, and recovery of area rent and etc., Lordship. So, petitioners, being the co-partner of the aforesaid land, Lordship, filed a petition under Order 1, Rule 10(2), seeking imprisonment as defendants, Lordship, which was dismissed by the Learned Trial Court, Lordship. And the next date of the Learned Trial Court is on 30/7/2026, Lordship. At this stage, Lordship, notice may issue, Lordship. Until returnable day, the impugn order may be stayed, Lordship. Immediately after filing of the suit, we have filed this petition, Lordship. WS not yet filed, Lordship. Suit was filed on 18/8 and we have filed the petition on 29/9, Lordship.
Learned counsel for the and has been directed against the order dated. Issued steps by speed post AD. 3 days. the what is required to be stated, the impaired order.
Lordship. Further proceeding in TS number 59 of 25, Lordship.
Till the next date of listing. List again on.
Oblige, your Lord. Lordship, in this case, I was directed to take instructions, Lordship. I have taken instructions, Lordship. He told me that he is at best to pay rupees 2,000, Lordship, DPL person, Lordship. Firstly, he said rupees 1,000, Lordship. Then said that more than 2,000 he cannot.
Mr. Learned Legal Aid Counsel represent the petitioner and has been directed against the order dated so and so, whereby the petitioner as plaintiff was allowed to withdraw the suit filed by him. Also is observed in the impugned order dated 4/4/26 that
Page 33 and 34, Lordship.
the defects in non-impleading necessary parties to the suit and errors in stating cause of action and other legal facts pleaded by the plaintiff can be considered as formal defects, warranting grant of the relief sought for, and it is also observed that the application has not been filed at a belated stage. Although there has been considerable delay after filing of the suit, which has caused harassment to the defendants. For that reason, a cost of rupees 10,000 has been imposed. Submitted that only the written statement has been submitted and no further proceedings have taken place, and the amount of rupees 10,000 awarded as caused by the learned trial court excessive, as the plaintiff person living below the poverty line, and the present petition also petitioner could not engage counsel on his own and applied for appointment of legal aid counsel. On instructions received, learned legal aid counsel has submitted that the petitioner capable and willing to pay a cost of rupees 2,000 on which under the aforesaid facts and circumstances is considered to be a reasonable one and can be accepted without notice to the. Accordingly, the petition stands disposed of by reducing the amount of cost from rupees 10,000 to rupees 2,000. Petition stands disposed.
IA number 2041, madam. And the other IA is IA number 1455.
Nobody has filed wakalatnama.
No, my lord. For the office note dated 22/7/26, there is no wakalatnama which been filed till today.
Now, who are these respondents?
They're the private respondents, my lord.
All are private.
They're all private.
So what to do?
My lord, as far as this particular application is concerned, this application I have filed under Order 41 Rule 3A. It is under a circumstance, my lord. If lordship may see this another IA number 1455, this is for delay condonation. Now the problem was, since there was a delay condonation, I have also filed a stay petition. Until and unless the delay condonation is condoned, I cannot ask for a stay. Therefore, the Honorable Court, when dealing with the matter previously, has asked me to file an appropriate application. This is the appropriate application which I have filed. This is the present, that is the present IA 2041. And for which I am also relying on a judgment by this Honorable Court.
So that is only for to show service, this IA.
No, my lord.
Yes.
No, this IE is particularly for asking for a stay, and this stay can be granted in a situation or a circumstances till the delay condonation is also pending. The Honorable Court can pass an order under Section 151. The ample power is given. I am also relying on the judgment. The judgment I have referred to, madam. Part of record, my lord, if lordship can find out the judgment, or else I have another copy. If I may go with the fact of the case, my lord. This is the judgment which I am relying on now.
Is the necessity of the stay?
Lord, what happened is it is fixed on 31/7/26. So what happened is this only.
Fixed for what?
My lord, this particular RSA which I have filed, this IRSA is against the order passed by the Honorable Civil Judge Senior Division Sunitpur. Basically, the factual aspect, if I see, my lord, may come to paragraph number 1, page number 4. Herein the present respondent number 1, 2, and 3, they are the legal heads. They have filed an application under Section 108 of the Indian Evidence Act. They are basically asking for the declaration of a death of their father and the husband. Now, on the first, this was the first prayer. The second prayer was they have the deceased father, the husband, was having a policy in the LIC Act. We have not contested the first prayer because we have got nothing to show whether declaration to be done under Section 108 or not. But on the second prayer, which was made that since he is having a policy and he is entitled to this sum assured. So basically, our contention was the person got missing from 4/6/2012, my lord. That is the specific date in the year 2012. The date of premium which he have paid, the first premium was of 2010.
It is the day of opening of the particular policy. On the subsequent dates, the yearly premium 2011 and 2012 was not paid by him. So the question of whether he went missing or not will not even arise at that point of time, because he passed away or he is missing since 2012, and the policy he failed to pay the premium was of 2011 as well. Now 11 and 12 he have failed to pay the premium. That is why he's not entitled for the policy's assured amount. That was our basic contention. So the learned trial court, the learned appellate trial court has rejected the contention that under section 108 of the Evidence Act itself, the case is not maintainable. Failing which, they have preferred an appeal before the learned appellate court, first appellate court. The first appellate court has considered their case under section 108 and declared this person to be dead. So subsequently, they have said that since we have a policy and the policy is required, the sum assured has to be given to them. The said contention, for said contention, they have relied on the particular policies premium that which have been paid by the policy holder. And this in the specifically, there is a mention of the date which says that only on 26 to 2010, this person has paid the premium. Despite of that, the judgment was passed that we have to pay the sum assured amount. This is which we are challenging right now in the RSA.
Now, is there a finding that he is to be regarded as having died before the after the payment of the premium immediately and before the next premium was
Yes,
due?
yes, that is the point. I was saying what I'm saying in the year 2010, the deceased person has opened the policy. On the opening of the policy,
2010.
2010.
So that he paid the premium in 2010.
Correct.
And what is the date of missing taken by the court?
4/6/2012. The next
4/6/2000.
premium, yes, the next premium is, my lord, 26/2/2011, which he failed to pay. Now, if we go for the third premium also, it will be 26/2/2012. But subsequently, for 2 years, he have failed to pay the premium. That is my case.
So let's see the finding of the appellate court.
Yes, ma'am.
Trial court went in your favor.
Yes, actually, trial court didn't discuss the second prayer. They have discussed only the first prayer, whether he is entitled to get a declaration under section 108 of the Evidence Act. On the first instance, the trial court has rejected that plea. So therefore, they have not seen the second prayer, the second contention. But in the first appellate court, the first appellate court has agreed to the point that yes, he is entitled to under section 108 of the Evidence Act, declaration was granted. And subsequently, if we see, Lordship may go to the finding. Lordship may kindly come to page number 30. Copy of the judgment.
What is this at para 68, page 36? There is a finding.
Yes, Lordship, may I request Lordship to see the RSA. The RSA is not there. The filing number is available in the RSA. It is there in the record. I have annexed all the documents which particular plaintiff at that stage, the present respondent, has relied on. If Lordship may see in page number 30, of the present petition, there is a mention in paragraph number 68. The evidence adduced by the defendant witness was based solely on computer printout exhibit A without proper authentication. Conversely, the plaintiff produced the premium deposit receipt exhibit 9. The Honorable Court has referred to the premium deposit receipt exhibit 9 and deposed the payment has been made regularly until disappearance. This is the basic documents on which the whole judgments was relied on. Lordship may kindly see the present RSA. There is a filing number of RSA is 3025. Page number 37. Page 37.
Yes.
This is exhibit 9. Lordship may see at compared by near to that there is mention. This is a case number so and so, exhibit number 9. The bottom portion, Lordship. This is exhibit 9, which the Honorable Court is referring to. There's a stamp, case number TS number 162/22, exhibit 9.
Yes.
Yes. Now, Lordship may see the first premium received. The heading after the LIC Life Insurance Corporation of India, after that heading, left-hand portion, first premium received.
Yes.
That is 26/2/2010. This is the only receipt which is there in the exhibit 9. And the person went missing in the year 2012. You can find out, or should I point it out, madam?
So this is of other than that, this page, previous page, this is the policy.
Yes. Other than that, this is the policy, my lord. This is, if Lordship may see, this is the day of opening of the policy, 26/2/2010. Serial number 1, 2, 3, and 4, but the typing is done below, my lord. Policy number is 4853389596. Point number 2, date of commencement will be 26/2/2010. And date of commencement of RICS, from when the RICS will happen, that is 31/3/2010. It is complete in the left-hand side, my lord. There is the box which is there. So my whole case is, my lord,
This is the only exhibit
this is the exhibit which
regarding payment of premium.
Yes, my lord, that is the only exhibit.
The court has probably misread the
Yes, my lord.
evidence.
Yes.
Need counsel for the applicant. So IA. One 455 is the condonation.
Yes, my lord. There are 57 days delay is there, my lord. The present IA where I am praying for stay, if the delay is not condoned, that is 2041. IA number 2041 to 20.
Yes, IA 2041.
Yes, ma'am.
Applicant as per consignment track report submitted by the petitioner. Notices have been served upon the respondents number 1, 2, and 3 on 04/07/2026. However, none has entered appearance. So order dated 18/6/2026, paragraph 2. Three and 4. Up to 31/7/26. There are it appears in view of the above that the matter is urgent in nature and therefore interim relief is taken up for consideration. Since the track consignment reports prima facie indicate service of notice, although formal note have not been received back after due service. Appears submitted by learned counsel for the that the learned appellate court had held at paragraph 60. What was that? 68. 68 of the impugned judgment that the petitioner had paid all the premiums in respect of the life insurance policy of the person presumed to be dead right up till the time before his death. Presumed that appears that from the record that only one premium at the time of initial, one premium at the time of the policy date was paid on what was the date?
26/2/2010.
Which was annexed as an exhibited as Exhibit 9 to the learned trial court. And besides that, there appears to be no other document on the basis of which the learned appellate court could have held as above. Of, since the presumed date of death was
4/6/2012.
2012 and the last premium was paid on
26/2/2010.
and the remaining premium during the And there is no document showing payment of premium for the next two premiums falling due on একটু একে হবো ইয়ার দুটা next হবো 11 and 12. The aforesaid circumstance for execution of the decree is stayed until further orders. List the matter again on.
Lord, may kindly see the IA number 1455. The last order was to the registry. Registry was directed to produce the track consignment, my lord. They have produced the same, and it appears that the notice have been already submitted. 1 and 1, 2 and 3, as far as.
Where is that note in 1455?
Yeah, 1455, my lord. This office note dated 15/7/2026.
Same thing.
Yes.
They will not get any different post-tract record than what you have submitted.
This was done earlier, my lord. This particular, it was delivered on 18/5/26.
I heard learned counsel for the petitioner, it was 1455. As per office note dated 15/7/2026. Postal journal and postal tracking reports indicate delivery of notice to the respondents number 1, 2 and 3. Although neither ready cards nor unserved notices have been received back. Full stop. Is the matter again on so and so. Maybe after this day they will appear.
Yes, my lord. My lord, if lordship may allow me, my lord, if possible, can the title execution number may be reflected in the order, my lord? This stay